Okay, I'm very excited to have on the Goldstein on Gelt show attorney Ronald Sharp. He has over 40 years experience in law, family law, divorce law, but then he actually developed his practice into the areas of trusts and estate planning, probate. And one of the things that we talk about a lot on the Goldstein on Gelt show, and in fact I deal with a lot in my day job, is the issue of how you deal with your money, especially in terms of passing it on to the next generation. And, well, Ronald, people often throw out the words like a will or a trust. Can you just give us a basic understanding of what's the difference?
Sure, Doug. People often come to me for a will, and they really don't know what the difference is between a will and a trust. And I explain it to them that a will is just written instructions to a probate court as to what you want done with your assets after your death. A trust is also written instructions, but it's not to a court. It's to your family, basically, telling them what you want done with your stuff after your death and who's going to be in charge of seeing that that happens, but it doesn't go to a court. And avoiding probate and avoiding the court involvement and the time and expense is one of the big advantages of a trust.
So a trust is a document which really continues on for a long time, possibly after you die, whereas a will, it just kind of wraps up your affairs, gives out your stuff, and then it's done?
Yeah, I often analogize a trust to kind of a family business like Doug's Hardware. Doug's Hardware owns the building, owns the bank accounts, owns all the hardware and the cash register and everything else. Doug dies, the hardware is still alive. It continues to operate, but new owners come in, and that's the family. They come in and take over control of your assets according to the way you've described in your trust document, and they don't need court's permission or pay any fees or expenses or anything else. So it's very quick, easy, and inexpensive for them.
Isn't it a little bit sort of, I mean, not to be morbid, but doesn't this sort of sound like trying to control everything from the grave?
And that's a good idea sometimes. I know. Well, for example, one of the main reasons that people should have a trust is not necessarily to avoid probate and court costs and all that, although that's important. But sometimes people have situations, a lot of people have minor children. They may have a disabled beneficiary, whether it's a child or an adult, or they may have people who don't know how to handle money. And those are ideal situations for a trust to control that money so that it's not wasted, that you don't turn over $100,000 to an 18-year-old who doesn't have it when they're 19. A trust can spread out and manage assets for beneficiaries who aren't able to manage it for themselves.
Mm-hmm. I got you. So the idea is that a trust would be something that you could use to control the situation when perhaps the people receiving the money might not really have the maturity or the ability to handle the money on their own, which of course begs the question, is there something that people should be doing during their lifetime to make sure their kids really could control the money?
Well, of course, that goes toward the parenting and child rearing, I suppose. You could get them practicing to do that, but the fail-safe is to make sure that there are controls in place and a person appointed, your trustee that you appoint to be in charge of your trust, who can make these decisions or help them make decisions about it. And sometimes there's a time limit on it. For example, with minor children, we will say if they're under age 30 at the time of your death, then these controls would be in effect. But if they're over 30, maybe they'd get it all at once, or maybe a third at 30, a third at 35, and a third at 40, or something like that. Mm-hmm. Any plan that you come up with can be done in a trust.
Mm-hmm. So let's try to dispel a myth I think that people have. Is a lot of people think, well, if you have a trust, you can just avoid taxes, whereas if you have a will, you're going to have to pay taxes. Is that a myth, or is there some truth to that?
Actually, there is some truth to that. It used to be a big deal when the estate taxes, for example, were levied at anything over $600,000. Now, for a married couple, you'd have to have over $10 million where you have to worry about estate taxes. So that part is not true any longer. But there are other taxes and expenses. A will has, because it goes through probate, there are probate costs involved, primarily attorney fees, and that can be thousands or even tens of thousands of dollars. There's also time constraints. Wills, by their nature and by statute, are required to be open for a period of time, where a trust can literally be wrapped up as soon as you identify the creditors and identify the assets, you can follow the terms of the trust and immediately end it. So, yeah, there are some expenses saved, and there's certainly time saved.
So there's certainly a lot of flexibility. We're talking with attorney Ronald Sharp, who has spent decades as an attorney helping thousands and thousands of people set up estate plans. One of the things, of course, that comes up, at least in my practice as a financial advisor, is people say, hey, Doug, we really like how you help us to manage our money. Would you be willing to be the trustee in our trust? And I always say to them, no, because I think that creates a conflict of interest. And anyway, that's not my specialty. I'm an investment guy, and you need to have someone who really knows what he's doing to be a trustee. How do you suggest that people choose trustees to manage their portfolios or their estates?
Well, it depends on the situation, of course. If you have minor children, the children can't be the trustees, of course, and so you may take a brother, a parent, a good friend, something like that. If you have a responsible person who can act as a trustee for people who can't act as their own trustees, then you name that person. In fact, sometimes it's a good idea to name two people to do it, so they kind of watch each other and help each other, and you have co-trustees. Generally, people name their children as their trustees who are also their heirs, and there are no restrictions on when and how they get their money. That's a typical thing. That way, the kids, instead of going to hire a lawyer, they just take the death certificate and the trust paperwork to the bank and to the insurance company and to the real estate office, and they can transfer everything into their own names, and that's it. It's a pretty simple thing, if they know what to do.
As opposed to leaving it in the trust, for example.
Yeah, I mean, sometimes the person who makes the trust requires that it be kept in the trust for a period of time until circumstances and conditions are met. But usually it's a matter of just distributing the assets and liquidating things so that they can be distributed. The problem that I've seen, this is a major problem, is that people go to an attorney, they have the trust created, fine, everything's great, they've got the trust funded, the assets are in the trust. Then the person dies. The kids have no idea then what to do. Okay, I've got this trust, but what do I do now?
Right.
So they go back to the attorney and pay $300 an hour for what they call trust settlement, which is really not much more than clerical work, and it ends up costing a lot of money. Even though they avoided probate, they're still paying. So what I do when I prepare trusts is I give people a set of very specific written instructions, including form letters they can use to tell them exactly how to settle an estate after the person dies, and they don't need an attorney. And I've had a lot of feedback from people. I included those instructions in the book that I wrote too on living trust, so that people can, for a few dollars, get written instructions on how to settle an estate. So it's a good thing to do.
Explain why it's called a living trust as opposed to other types of trusts.
Well, there are a lot of kinds of trusts. I mean, dozens of kinds of trusts. A living trust just means a trust that's created while you are living and not one that goes into effect or is created at your death. There are trusts that are created within the language of a will, and that is called a testamentary trust. It's in your last will and testament. That kind of trust has to go through probate before it's created. That's not what we want. We want a trust that is created while you're alive. While you're alive, you're in charge of it. At your death, it can't be changed, but while you're alive, it's revocable, which means it's changeable, and you can use any of the assets any way you want. You can change your mind about anything during your lifetime. So that's usually they call it a revocable living trust.
And is it about as hard to create as a will?
It's a little harder to create because a will is usually 4, 5, 6 pages long. It just says who's in charge and who gets your stuff after you're gone. A trust may contain more than that. It says that, but also there may be conditions and that sort of thing. But after you create the trust, then you have to what we call fund the trust. You actually, as in the hardware analogy, you have to put the hardware store in the name of the trust and the bank account in the name of the trust, and your furniture is in the name of the trust. Everything is owned by the trust, so there's nothing left in your name at your death to be probated. However, just because it's in the trust doesn't mean you are in any way restricted as to your access to these assets during your lifetime. You don't have to file any special papers or anything to sell your house or access your bank account or anything else. So it doesn't complicate things. It just makes things simpler after your death.
Got it. Certainly a lot of benefits, and there's a lot more to learn about living trusts. Unfortunately, Ronald Sharp, we are just about out of time, but tell us in the last few seconds, how can people learn more about the work that you do?
A really good resource, and I know this is blowing my own horn, but
Now's the time. Now's the time in the interview to suggest
a really good resource is the book that I wrote, which is Living Trusts for Everyone, and the new edition is out in March of this year. But Living Trust for Everyone has got all of this information and much more, and it's available through the publisher or on Amazon. So that's a good resource for all of these things. Plus, frequently asked questions and that sort of thing.
Okay, we will put a link to that at the show notes of today's show at goldsteinongelt.com. Ronald Sharp, thanks so much for taking the time.
Thank you for talking to me, Doug. I appreciate it.
You've been listening to the Goldstein on Gelt Show with money maven Doug Goldstein. Check out all of Doug's money ideas at goldsteinongelt.com. Doug specializes in helping people who live outside the United States handle their U.S. investment accounts. If you have a question that you would like answered on the air or off, contact Doug at his website or send him an email to doug@profile-financial.com.